I will cover only 3 quick subjects, starting with the issue of the 50% plus one.
Rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate
Yes.
how this was happening.
Yes.
What we do with the demonstration. Mr. Mahat, on your side, did demonstrate, and they have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this match, not for us, but as required by the Constitution.
Mr.
But anyway, the long and short of it, yes.
The long and short, yes. We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with. There were responses from the other petitioners. I'm beginning with number 1, the same order we followed. You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Ladyship, Madam Deputy Chief Justice, my lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner in number 1, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on. So then we start
with the main petition.
That's
their
fine.
Rejoinder, then we come to you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Olengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Mtata.
They will respond with their rejoinder.
With their rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Murgor, and I'll have 5 minutes at the end. But I'll begin with Senior Counsel Otiende Amolo.
If If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus one. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kimskit. It will be noted by this honorable court that at various times, the Iebc gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which Iebc proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, your ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The Iebc did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kimskit, the figure they are seeking to use is 22,005,541. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of Iebc is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the president of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, your lady, it is the decision of the majority that must be the decision of the court. And similarly to the Iebc, as we are here today, the decision of the Iebc is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the Iebc that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision by Iebc itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the Iebc. The verification has to be done by the Iebc. The declaration decision has to be made by the Iebc. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important